If you were hanging out, shooting the breeze with your boss and coworkers at an after-hours gathering while still on work property, when 3 to 4 men in an unknown vehicle drive through the parking lot several times, throwing bottles and threats of harm at your group, and you in particular, wouldn't it be reasonable to be alarmed and call the police? Getting the police involved would initiate an investigation, identify the strangers, ensure the employees are safe, and ensure that the clients are safe, and maybe even result in the arrest of whoever these men are. Any reasonable person would call the police. So imagine you ask the restaurant manager, who's also your boss, who's also there, he's also seeing the escalating threats, he's also subjected to the thrown bottles, for permission to open the locked restaurant door so you, him, anybody could call the police. What if you asked your boss, a reasonable person mind you, to call the police because you felt scared and he wouldn't? What if you asked your boss to make the phone call that could have prevented bodily harm and he wouldn't? What if you begged your boss to open the door, to call the police, to report the danger, and he refused because it's against company policy? And so, with your request denied, you leave the group and begin to walk home. You cross the street, and within minutes, you are gunned down by the same malicious men in that vehicle. Not only have you been shot, but while recovering in the hospital, you have been fired. In that scenario, you would be Mr. Ethan Bigpond. Good evening. My name is Jessica White, and I'm the attorney for the plaintiff, Mr. Ethan Bigpond, the young man of Indian descent sitting over there. And at the other table sits the attorney for the defendant, Florida Company Shrimp and Ale of Florida Incorporated, which is a restaurant franchise company maintaining 9 restaurants and a headquarters in Attica, Florida. I'm sure defense would join me in extending my thanks to you for agreeing to sit as our ultimate finder of fact. You have a very important role in these proceedings, and we appreciate your time. That scenario was a real incident that occurred to Mr. Bigpond at Shrimp and Ale restaurant on August 26, 1995. Since suffering a gunshot wound and being fired from his dishwasher position, my client has filed a claim of negligence against Shrimp and Ale of Florida Incorporated. Members of the jury, this is where you come in. You are here to help us settle a dispute about whether Shrimp and Ale of Florida was negligent in incident where Bigpond was shot, and if so, whether such negligence was a legal cause of injury to Mr. Bigpond. You are here because Mr. Bigpond would like you to answer some simple questions. Doesn't the boss in Shrimp and Ale of Florida Incorporated bear some liability to him for being shot? Shouldn't a restaurant manager do like any reasonable person and call the police if a restaurant guest or employee asks him to report threats occurring on restaurant property? Wouldn't a company be liable for any harm resulting from threats made on company property if their supervisor failed to act like a reasonable person by refusing to call the police? Florida law states that negligence occurs when a duty exists, when that duty is breached, and when a harm is proximately caused by that breach of duty. Furthermore, the resulting harm can have more than one cause and still be considered a legal cause. Under Florida's pure comparative fault scheme, even when the victim of the harm is at fault for his own injury, he may still claim for the remaining percentage he's not at fault for. It is our position that the greater weight of the evidence will prove that Shrimp and Ale were negligent. It is their position that young Mr. Bigpond here is responsible for being shot after and in spite of Mr. Bigpond's request for police assistance, which was denied by their manager. However, we expect to show that manager Jordan Sparks had a duty to call the police like a reasonable person would. like a supervisor would, like a person in charge of protecting property, paying guests, and coworkers would. So it's our position that defendant owed Mr. Big Pond a legal obligation to take care to avoid causing harm to Mr. Big Pond, because Mr. Big Pond was a paying restaurant guest and not just an employee on the premises at the time that the incident began. Also, their manager, Jordan Sparks, was acting in the scope of his duties and in furtherance of the company's policies and the company's interests when he complied with their policy and refused to re-enter the restaurant and called the police. You will hear testimony that on August 25th, 1995, 18-year-old Mr. Big Pond walked the 1 mile from his house to his workplace, Shrimp and Ale, on his day off to have a late 11 p.m. snack, watch the game on the restaurant's TV, and stay for the weekly beer fund party. Mr. Big Pond will testify that he was there when the restaurant closed at 1 o'clock in the morning on August 26, 1995, that he helped his restaurant's closing manager, Mr. Jordan Sparks, and co-workers clean up, and that he then joined them for drinks in the restaurant's parking lot. You will hear from Mr. Big Pond that every Friday night after closing, most of the employees gathered around behind the restaurant, contributed money to buy beer, and then stayed until the beer was completely consumed. That night, there were about 7 people present, including manager Jordan Sparks and waitress Dana Austin, who will testify to the same. You will see evidence in a memorandum dated July 3rd, 1995, but never sent, that Shrimp and Ale's regional manager, Mr. Cody Adams, knew about these after-hours parties on company premises because it was relayed to him by the chief of police. Dana Austin, who is a waitress and was also there that night, will also testify that a little after 1:30 in the morning, a vehicle with several unknown males drove through the parking lot at least 3 times, throwing bottles at the group and yelling at Mr. Big Pond. Mr. Big Pond will testify to the specific threats, and that these men threatened to get the Indian before the sun came up. As you can see, Mr. Big Pond is an Indian. He was also the only Indian in the group that night. It is true that Mr. Big Pond attempted to scare off the unknown men and that the men drove away, yelling to Mr. Big Pond, "We'll get you later, red man." Florida law states that doing something wrong, or not doing something at all, constitutes an act of negligence. We further expect to show that Jordan Sparks breached that duty by refusing to open the restaurant and refusing to allow a simple phone call to the police. The evidence and testimony will show that the men left at around 2 o'clock in the morning, at which time Mr. Big Pond asked Mr. Sparks to open the building so he could call the police because he was scared to walk home. Mr. Sparks' testimony will show that Mr. Big Pond did say he was really scared, that he really needed to use the phone. Mr. Sparks will also admit that he did not open the building and he did not allow Ethan, Mr. Big Pond, to use the phone because of company policy. Mr. Cody Adams, Shrimp and Ale's regional manager, will also testify about the company policy, which underlines that managers may be immediately terminated for re-entering a Shrimp and Ale building after the restaurant is closed and locked. Mr. Austin's testimony will reveal that Mr. Big Pond returned to her after speaking with the manager and told her that he was scared, but that Mr. Sparks refused to open the building and refused to call the police. Having been denied assistance by Mr. Sparks, who was acting in the interests of his employer, Shrimp and Ale Incorporated, Mr. Big Pond resigned himself to the 1-mile walk from Shrimp and Ale to his house. Finally, evidence will show that but for the phone call, the harm of being shot would have been avoided, and that the harm that did befall Mr. Big Pond can be contributed to Mr. Sparks' unreasonable refusal to open the building and allow a phone call to the police. You will hear that Mr. Big Pond, having been denied help, had hardly walked across the street when he was almost immediately shot by the unknown men in that same vehicle that had patrolled the parking lot earlier, throwing bottles and slurs at him. Mr. Big Pond will testify to the gunshot wound he received in his leg. You will also hear from Mr. Sparks that Regional Supervisor Cody Adams instructed him to terminate Mr. Big Pond. He was still recovering in the hospital, and to hire a new dishwasher instead. Members of the jury, when you've heard all the evidence and the circumstances of how my client came to be a drive-by shooting victim while leaving the Shrimp and Ale restaurant, I am confident you will find that Defendant Shrimp and Ale Incorporated owed to Mr. Big Pond a legal obligation to open the restaurant and allow for a simple phone call to the police. That they breached that obligation when their manager refused to open the building and caused and contributed to Mr. Big Pond being shot in the right leg. To add insult to injury, Defendant Shrimp and Ale Incorporated terminated Mr. Big Pond while he was still recovering in the hospital. I'm confident that you will find Shrimp and Ale committed negligence by failing to take reasonable care to avoid causing harm to Mr. Big Pond, who was a paying restaurant guest, not just an employee, on the premises at the time the threats of violence began. Even if you do think that he has some part in causing himself to be shot while leaving the restaurant, I'd like you to think about how one phone call could have avoided this unfortunate incident. Please find in favor of my client, Mr. Big Pond. Thank you.